With us now are Michael and Stephen, and we're going to be discussing intellectual property. And in fact, they're helping me with a trademark. Welcome to the show. How are you both? You good today?
Great. Thanks for having us, Donna.
Great. Intellectual property. You work at Dilworth and Barrese, right?
Correct.
So Michael, what do you specify in? I know you kind of work with patents, right? What is
Correct.
intellectual property overall? And then let's discuss patents.
Well, intellectual property is anything that a person will create. It could be copyrightable material, such as music or textual works. It could be inventions, such as a machine or a process or a chemical compound. And then it could also include trademarks, which Steve specializes in.
So Steve, what are trademarks?
So trademarks are words, phrases, logos, or combination of all that distinguish someone's goods and services from others. So it gives you exclusive rights to use these terms or phrases on specific goods and services.
Now, one of the things I noticed over the course of time is that I am a living person, right? So even my name, as a living person, I had to say to someone, okay, the Donna Drake show represents a living person. It's very complicated. A lot of times people think that they're going to make their own logo and that's all the protection that they need because they made their logo. But that's not necessarily the case, correct? Why is it important to make sure that your mark is trademarked?
Well, first of all, like you said, most people think that they get a phrase or logo and it can stop everyone in the country from using that phrase or term. But that's really not the case because it's specifically for goods and services. So you could have the same name in two completely different industries that could share that name. That is trademarked.
Okay.
But as far as why you would want to get something trademarked it's your brand, and you want to protect your brand from somebody else using that name in the same field, competing with you.
There used to be a beverage called Like was a soda, right? And they had, a certain, I guess, trademark, if you will, because it was a brand. It was the piece of art, really, that labeled that brand. But then the formalization would also be, I guess, something that you would patent. So in that case, you would need both a patent for the formalization, correct, as well as the trademark for what it's called. Is that right, Mike? You would need both, Michael?
Well, the patents, as far as ingredients in a particular product, that's not the subject of patents,
Okay.
particularly. That would be more of a trade secret, which also falls under intellectual property.
Okay.
So formulas and the ingredients in products that are out on the market, just like the Coca-Cola brand, that's a trade secret, and they keep it a secret that way in order to protect their formula. So that's another area of intellectual property.
But if the bottle had like a special type of cap, right, that was maybe like a flip top, that would be something that you could patent.
Correct.
Okay.
Any mechanical structures like that are the subject of patents, and there's many, like the flip top, the shape of the Coca-Cola bottle is patented in a design patent, which they protect very well in their products.
So both of you, I was asking you before, like what your hobbies are. I know that you're both type of creative people. Is it fun for you to be able to help somebody take their creative ideas and their intellectual property and like protect them? Is that like a fun process when they finally get that special number that says, boom, you own that?
Yeah, I mean, it is fun. And, we have clients from all different areas, as small as restaurants to as large as, cell phone makers.
Okay.
And, it's fun to get the trademarks. And, I be driving down the road, I see a truck with the trademark that I got, help them register. And, it's satisfying. Yeah.
It's the same thing for patents too. I
It is?
enjoy working with the inventors,
Right.
Small and large companies. But when you have a small inventor working out of his garage, or a startup company that's just building their IP portfolio, to help them and guide them through that process, what they need, even when it comes down to their budgeting, to help them in that side of it. It's always a wonderful thing to watch them grow and really start hitting the market and making it big.
There's an inventor that came on my show probably about a year and a half ago. And what they invented was this little cube that helps when the door, like a door jamb, right? So that children's fingers don't get caught in the door. And I've had this cube laying around, like 18 months or whatever now. And then all of a sudden I was like, oh, and I found a reason for it, which is in Studio C. That door automatically locks behind you, but now it's got like a magnet. It's just this little cube. You stick it in there and boom, and he has the patent. Sometimes it says patent pending. Does that mean like you've got a great invention, but like Michael, you're in the process of making sure that it gets done?
That's exactly what it is.
Okay.
Yeah, you prepare and file an application with the United States Patent and Trademark Office, and that application then gets examined by a patent examiner. And during that examination process, you could use the term patent pending to put other individuals and companies on notice that there is a patent application on file that may issue into a
Like
patent.
they got there first.
Yes,
Meaning like
exactly.
you might think you've got the idea, but we got there first.
Correct.
Right? I think that's the other reason too that it's important to make sure that you get all of the legal issues taken care of. It's really to protect you. Like if you're smart enough to invent something or create a logo or you have a brand, it's important because there's value in that, right? There's value in that. And it's nice that you have this company where you're helping people respect the process.
Yeah, and
So-
that's exactly right. Specifically with trademarks, it's an asset. And your brand is an asset. You sell a company, what are you selling? You're selling your brand. And I've had several companies that had trademarks that we filed for them and have family of trademarks and go on to sell that company for 10, 20, $30 million.
Well, I hope that happens with me. No. In all fairness, when I started the show, I used to call it Live It Up. And now it's a hybrid. It's the Donna Drake Show, Live It Up, right? Because I didn't really want to get away from the purpose of why it was called Live It Up. My husband, Tom, that had passed away, wrote a song, Life is Only What You Make of It. And 17 years ago, when I started the show, I called it Live It Up because it was short for that. But my mission remains the same. And I had tried to register the trademark years ago by myself. I did an okay job. But there's a process where they keep contacting you. And you need to be able to respond to these things. So now, since that trademark had expired, right, I hired you guys, and I'm really thankful because you're going to help walk that through, right? Because my Live It Up mark is cool. It's got an upside down, exclamation point. It has zest. It kind of looks like what it is that I do. So I thank you for that. So not only are you a guest on my show, but I'm also your client, right?
Yes.
In full disclosure. I thank you. Are there any other things that you think that the audience might want to know about trademarks or patents? I think you guys did a really good job explaining it. I kind of fumbled through it thinking the patent was the formalization, but that's not. That's intellectual property, and it's the mechanism that is the patent.
Sure.
Okay.
Yeah.
Yeah, the one thing I could say is, trademarks are good for 10 years.
Okay.
But they're renewable every 10 years. So you could theoretically have a trademark forever as long as you maintain the trademark and file the renewals every 10 years. Patents are different.
Patents last for a 20-year monopoly that the government gives you. So
20 years. It doesn't really seem like enough, does it? I'm just saying.
they've worked that out over
Okay.
the years,
Okay.
and it seems like if a company has a product, the life of the product is usually around that 20-year mark. That after that, actually the patented idea goes into the public domain.
Oh.
So you have 20 years to make money and exclude others from your patented product, and after that, anybody can practice that particular invention.
My great-grandfather, George Stevens, had a patent for fire doors, and I was able to look it up, and I was able to take a picture of the schematic. And my youngest son is becoming an engineer, and I thought, oh, this is kind of cool. So sometimes you can also frame those things. It could be like a family, gift to
Yeah,
someone.
the patents still they still publish the patents, and many of our clients have them hanging on their walls in their company offices. Yeah.
And the company that you work with, I know it's been around for a long time, right? Because you're the
Yeah,
second
almost 40
generation.
years.
Or, okay.
My father started it in 1987, and we've been keeping it going for all these years. We have relationships around the world. We file patents outside of the U.S. with other attorneys that we've known for a really long time. So, I think we're doing something right.
Yeah, I think you're doing a lot right, guys.
Yeah.
Thank you so much. Thank you, Michael. Thank you, Stephen, for joining us.
Thank
If
you.
you have some intellectual property that you want to protect, please reach out to them. And thank you for watching.